I could sit here and record this podcast and bore you all day long with Florida statutory law about the do's and don'ts, the musts and the have-nots of the Florida prenuptial agreement. But instead, what you really want to know is, do you need one? Why do you need one? And when should you have one written and drafted? First and foremost, I believe you absolutely need one. If you're going to get married and one or the other party has a substantial income, business income, a higher level career, a prenuptial agreement is essential. Here's why. If you're ever going to have a divorce and you do not have a prenuptial agreement governing how your divorce is supposed to go, who is going to have what percentage of the house, who is going to have alimony and in what amount and where and when and why and how frequently, how long, how much. If you do not have the most essential parts of your divorce mapped out and planned for, and your divorce turns out to be contested, you could be in court for 2 to 3 years, spending tens of thousands of dollars on legal fees, and perhaps even for both sides. You might have to pay your spouse's legal fees. And one of the things that you're going to regret is not having planned this, not having mapped this, not having understood the whole purpose of a prenuptial agreement, which really is the protection of both parties, not just one. A prenuptial is not intended to protect just one party, it's intended to protect both. Let's take a classic example. Wife is a physician, earns $350,000 a year. Husband is generally in sales. His highest grossing income is approximately, let's say, $55,000 a year. With inflation and modern monetary issues such as they are, that is not a heck of a lot of money. 5, 10 years ago, that was a very reasonable, good salary. With inflation, that's very difficult to live on. $350,000, however, is a substantial upper level, perhaps top 1 or 2% salary. So, if these two folks are intending to get married and they want to protect their assets and they want to ensure that if they're ever going to be divorced, there's going to be fundamental fairness where neither side is financially wrecked and both sides are protected and both sides are provided for, they can have clarity. You can ask your family lawyer to draft a prenuptial agreement, also sometimes called an antenuptial agreement, depending on what state you reside in. But really, it's a prenup. The stigma surrounding a prenup is outrageous. I can't believe you had to sign a prenup, or I can't believe you didn't get a prenup. This conversation goes both ways, depending on your friends, your family members, your nosy, intrusive neighbors. I know a person that had a prenup and they such and such, or I knew a person that didn't sign a prenup and they got hosed in their divorce. Well, let's just demystify right here and right now. Florida is an equitable distribution state, not the wife gets everything state or the husband gets to keep everything state. Equitable distribution inherently presumes equal distribution. How to get there is the tricky part. How that actually works once all the facts are presented, somebody's dissipation of assets and spending habits is an entirely other issue for another podcast episode on another day. For right now, here's what we can say. A prenuptial agreement is a map. It is a plan. It will function as your essential marital settlement agreement in the instance you are divorced. Now, yes, in the next 5, 10, 15, 20, 25 years, things can change. Maybe that doctor is no longer working due to disability or is taken on a different job and no longer makes $350,000 a year. Maybe the husband now makes $150,000 a year and is a regional manager and has upgraded and elevated his career status substantially. Things can change. You can abrogate or rescind a prenuptial agreement based on mutual agreement. You can do any number of things. But right now, to the best of your knowledge, with what you know going into this marriage, you're going to want to plan. So how do you do it? Step number one, and this is painstaking and nobody enjoys it. Step number one is make a list, maybe even using a financial affidavit. Make a list of all of your assets and your liabilities, loan agreements, mortgage payments, car payments, credit card debt, and your spouse or future spouse should do the exact same thing. You are both going to have to exchange those documents. Of course, can you get away without doing it? Yes. Your prenuptial agreement could potentially be declared invalid someday if you don't actually provide these things to one another. As Florida law recommends a full and fair disclosure, even if you waive that right, it could reduce the potential for enforceability of your agreement, and you will share with each other all of your debts, all of your liabilities in any capacity, all of your assets. And when your spouse knows what you're worth or what you are not worth, what you have in debt versus how much they actually have in money now, that will be very helpful in making a decision for how to structure this prenuptial agreement. One party can assume all of their own debt as it is their debt before they get married. The other party can delineate or define what is their premarital property. Now, let's take a classic example because this is something that's on everybody's mind. I don't think I've ever had a conversation with somebody about a prenuptial in which something similar to this did not exist in a personal or professional capacity, either or both. And that is this. If you are in a circumstance where you are the owner of a home or a series of properties or strips of land in various places, in various states even, and you're going to be married, maybe you will make a gift of one tract of land or one of those investment properties to your future spouse as part of this prenuptial agreement. But if you're not going to do that, and even if you are, you will want to define all of them or a vast majority of them as premarital property. Can you, at some future date, on your 10th anniversary, on a silver anniversary, a golden anniversary, say, hey, we've been together forever. We have children together now. I love our life together. And I want you to feel secure in case anything ever happens, aside from inheritance purposes. You can then do something wild. You can gift that property to your spouse, title it in both parties' names as tenants by the entirety with a joint right of survivorship. So whatever happens, whoever predeceases the other party will then receive that property in full. You can make practically any lawful arrangement you like in a prenuptial agreement. It is a way to protect the other spouse and protect yourself at the exact same time. It's a way to avoid potentially hostilities. If one party believes that they should have received something that they never receive, or they had unrealistic expectations and you didn't share those expectations, get it out in the open. Plan for it. As far as alimony goes, under Florida law, while you can't make a prenuptial agreement involving time sharing or child support with children, as that's contrary to public policy and things change, and you might not even have children yet, so to define time sharing would be ridiculous at this point. You can, of course, decide how much you want to have in alimony. You can make it tiered based upon the length of marriage, although that doesn't happen often. You can make it a maximum amount, a percentage of your income. You can do anything that's reasonable as long as, I will mention a little statutory law just because it's important here, as long as you do not leave the other party destitute and on financial services or financial aid from the government. That is against public policy. You may not leave your spouse impoverished. You generally may not shock the conscience of the court by making an agreement which impoverishes them to the extreme and leaves you with everything just because. Okay, so let's just recap. Prenuptial agreement is a great idea. It's not intended to punish one or the other party. It's not intended to provide security just for one party. It's intended to provide clarity so you know what to expect in the instance of a future divorce within reason. You can't possibly know what the future holds, but you can plan for the best case scenario for both parties so each potential spouse goes into this marriage understanding what will happen if they are ever broken up and divorced, understanding that they have some measure of security, some measure of clarity, and that this marriage is not being sought after for financial gain or financial loss or anything like that. It's being sought after out of love and because of mutual affection and a desire to have a life together. This has been episode 2 of the Best Family Law Podcast with attorney Jonathan Jacobs of the Jacobs Family Law Firm. So glad that you were entertained by us for just about 10 minutes or so, and I look forward to the next one. Thanks.